Hello, and welcome to an update on medical assistance in dying in Canada. In other words, a review of the changes that Parliament has made to move us from Bill C-14, our first law, to Bill C-7, our new law. My name is Jocelyn Downie, and I'm a professor in the Faculties of Law and Medicine at Dalhousie University in Halifax, Nova Scotia, Canada. One quick caveat before diving into this update, there is law specific to Quebec, and I won't be covering that here. So this is specific to the Canadian law. So let's begin our exploration about what's different between C-14 and C-7. There are 5 categories of changes to be aware of: eligibility criteria, procedural safeguards, advance requests, reporting, monitoring, and analysis, and independent and parliamentary reviews. So first, the eligibility criteria. C-7 makes 2 critical changes to the eligibility criteria for MAID. First, it deletes the requirement that a person's natural death be reasonably foreseeable. It's important to note this is not evidence of a descent down a slippery slope. It merely returns us toward the access that was granted by the Supreme Court of Canada in its decision in Carter. And the second change to eligibility criteria tweaked the requirement that a person has a serious and incurable illness, disease, or disability. Specifically, it is a temporary exclusion of mental illness from the illness, disease, or disability in the statute. In other words, you are ineligible if mental illness is the sole underlying medical condition. Now, this is temporary because there's also a sunset clause in the legislation. In other words, the exclusion automatically disappears from the law in 2 years' time. It's important to note here that mental illness is not a blanket exclusion. You can still be eligible for MAID and have a mental illness. It's just that at the moment, you need another serious illness, disease, or disability too. So that's the big changes in eligibility criteria. We also have some new procedural safeguards. The big change is that we have 2 tracks, 2 sets of safeguards. One is for people whose natural death has become reasonably foreseeable, and one is for people whose natural death is not yet reasonably foreseeable. So the expression NDRF is still with us. It's just not an eligibility criterion. It's the determining factor for which track to follow. In other words, it's not whether you can have MAID, it's how. Okay, so let's go through the major changes with respect to procedural safeguards. Under C-14, another physician or nurse practitioner has to provide a written opinion confirming that the person meets the eligibility criteria. For track 1 C-7, there's no change. But for track 2 C-7, it's the same requirement plus if neither the first physician or the second physician or nurse practitioner has expertise. Note, this is not saying you have to be an expert, but you just have to have expertise in the condition causing the person's suffering. The first or second practitioner must consult with a physician or nurse practitioner with that expertise and share the results of the consultation with the other practitioner. And I would note here that this is not the person with expertise doing a MAID assessment. It's important to know that because if it were having to do a MAID assessment, it would affect the willingness of people with expertise to participate in this process. It's not that. They are doing a consultation with the people who are doing the MAID assessments. Okay, another change has to do with witnesses. C-14 said the request had to be signed and dated before 2 independent witnesses. But C-7 track 1 says it only needs to be 1 independent witness, and the same for track 2. Now, what they also did was tweak the independence required of the witnesses. So we went from 2 to 1, but also they have changed the understanding of independent. Under C-14, an independent witness could not be directly involved in providing healthcare services to the person making request and could not directly provide personal care to the person making the request. However, under track 1 C-7, a person who provides healthcare services or personal care as their primary occupation and who is paid to provide that care to the person requesting MAID is permitted to act as an independent witness, except if they provide MAID or an opinion about the MAID criteria. And then track 2 has the same requirement as track 1. They've also changed what you have to inform the patient about and offer. Under C-14, you have to give informed consent to receive MAID after having been informed of the means that are available to relieve their suffering, including palliative care. There's no change for track 1, but under track 2, the person has to have been informed of the means available to relieve their suffering, including where appropriate, counseling services, mental health and disability support services, community services, and palliative care, and has been offered consultations with relevant professionals who provide those services or that care. C-7 also changed what the person requesting MAID has to have done. There's no equivalent for this provision in C-14 or for Track 1 people under C-7, but under Track 2 C-7, both of the physicians and nurse practitioners have to have discussed with the person the reasonable and available means to relieve the person's suffering and agree with the person that the person has given serious consideration to those means. Changes also to the waiting period. Track 1 no longer has a waiting period, and Track 2 has a longer one. Under C-14, 10 clear days were required between the day on which the request was signed and the day on which MAID is provided, unless both the physicians and nurse practitioners are of the opinion that the person's death or loss of capacity is imminent. Any shorter period the first physician or nurse practitioner considered appropriate would then be allowed. Under C-7 Track 1, there is no longer a waiting period at all. Under C-7 Track 2, you now have 90 clear days required between the day on which the first assessment begins, not the request being made, but the assessment begins, and the day MAID is provided, unless the assessments have been completed and both physicians and nurse practitioners are of the opinion that a loss of capacity is imminent, at which point any shorter period the provider considers appropriate is allowed. We also have changes with respect to the requirement of express consent at the time of provision. 2 exceptions have been introduced. Under C-14, there was a requirement that immediately before providing the MAID, the person be given an opportunity to withdraw their request, and the physician or nurse practitioner ensured that the person gave express consent to MAID. Now for C-7 Track 1, there are 2 exceptions to this. One's called the final consent waiver and one is called advanced consent. And for Track 2, we have the exception, just the advanced consent exception. So let me tell you about advance requests. This is a huge change in the law. Advance request is an umbrella term, and they're only allowing 2 kinds under C-7. So advance requests are requests for MAID made in advance of lost capacity, and there are 2 kinds that are permitted. The final consent waiver, this is for people who have been assessed and approved as eligible for MAID, and the advance consent, which is for provider after failed self-administration. Few details on these. So for final consent waiver, known as assessed and approved, the person has to meet the eligibility criteria for MAID, Track 1 only. So natural death has to have become reasonably foreseeable and has to be at risk of losing capacity to consent. Then what they can do is have a written arrangement between the provider and the patient for MAID to be provided on a specific day. And consent is given in the written arrangement to the provision of MAID if the person loses capacity prior to that day. And you can have MAID then on or before that day. MAID cannot be provided, however, if the person demonstrates resistance or refusal. But I would note that involuntary words, sounds, gestures made in response to contact do not constitute refusal or resistance. Now, the second kind of advance request is advance consent, and this is for failed self-administration. So a person has to meet the eligibility criteria for MAID, and this can be Track 1 or 2. And then the written arrangement is that the provider would be present at the time the person self-administers and would then administer meds to cause the person's death if, after self-administering, the person lost capacity to consent to receiving MAID and didn't die within a specified period. This change to the law was designed to prevent the fear and to remove the risk of criminal liability if a person did provider administered after self-administered. So now let's look at some changes to reporting and monitoring and data analysis. So with the reporting requirements, under C-14, you had to report all cases in which a written request for MAID was submitted, and the report had to come from the physician or nurse practitioner who received the written request. Now under C-7, all cases in which even a preliminary assessment takes place have to be reported. I would note here that there's not yet a precise definition of preliminary assessment. That will come through the consultation process that will be conducted on the necessary revisions to the regulations on reporting that will take place over the course of the next couple of years. Under C-7, it is now also any person with responsibility to carry out preliminary assessments who will need to report. And pharmacists and pharmacy technicians who dispense a substance in connection with the provision of MAID will also have to report. C-7 has also has expanded what needs to be reported. What is included now is the elements considered in the course of the assessment, preliminary or otherwise, of whether a person meets the eligibility criteria, and also information respecting the race or indigenous identity of a person who requests or receives MAID, if the person consents to providing that information, and also information respecting any disability of a person who requests or receives medical assistance in dying, again, if the person consents to providing that information. Now, the government also expanded what they will do with the information that they get. The use, analysis, and interpretation of the information gathered, including for the purposes of determining the presence of any inequality, including systemic inequality or disadvantage based on race, indigenous identity, disability, or other characteristics in MAID. This will surface either that people are inappropriately getting access to MAID, and that's in relation to systemic inequality or disadvantage, but it also may demonstrate, once we analyze the data, that people are actually facing unequal barriers to access to MAID, and we will see. It will take a couple of years to revise the regs and then start gathering the data, and then we will have that information available to us about how MAID is working in Canada. Now, there are also some changes made to the reviews, independent and parliamentary reviews. So under C-14, there was independent expert review on the issues of mature minors, advance requests, and requests where mental illness is the sole underlying medical condition. Now, this panel, the expert panel, was not mandated to provide recommendations, indeed was not allowed to make recommendations on its review of these issues. But the CCA expert panel reports were conducted on these issues and were submitted to Parliament in December of 2018. Now under C-7, we're going to have an independent expert panel review. It is still to come. What it will do is recommend protocols, guidance, and safeguards to apply to requests made for MAID by persons who have a mental illness. This report from this independent expert panel will contain conclusions and recommendations, and these must be provided to the ministers no later than March 17th, 2022. And then the ministers must cause the report to be tabled in each House of Parliament within the first 15 days on which the House is sitting after the day on which they receive the report, so likely sometime in spring 2022. So note, this is a review about the implementation of the eligibility for MAID by people with mental illness as their sole underlying medical condition, because that is going to happen in 2 years' time. And this is about the implementation of that. It's about how, not whether, MAID for mental illness, where there's a sole underlying medical condition, will take place. Okay, the parliamentary review. Well, from C-14, Parliament was supposed to have started last June, a review on the provisions of C-14 and the state of palliative care. That review never started, let alone completed. Under C-7, this review needs to take place, and it will have an expanded scope. So this parliamentary review will be a review of the criminal code MAID provisions and their application, including but not limited to the issues of mature minors. So those are individuals under the age of majority who have decision-making capacity, advance requests beyond the scope of the two exceptions that I told you about, the final consent waiver and the advance consent in the context of failed self-administration. Mental illness, any number of aspects of MAID for mental illness, the scope is not limited. The state of palliative care in Canada, and also the protection of Canadians with disabilities. Under C-14, the parliamentary review was supposed to be a committee of the Senate and the House or both, and was supposed to be referred at the start of the 5th year after the day on which the act received royal assent. As I said, it didn't happen. Under C-7, they have settled on how and ramped up the pressure to get going. It will be a joint House and Senate committee. They are to commence the review by April 16th of 2021. That has actually been delayed. They haven't fully named the committee yet. They are due to submit their report no later than April 16th, 2022. Of course, this could all be upended by an election that may happen. We just don't know. Now, a parting word on something that did not change as between C-14 and C-7. C-7 did not change the meaning of natural death has become reasonably foreseeable. And natural death does not mean a 12-month prognosis or a 24-month prognosis, or indeed any specific prognosis. Natural death has become reasonably foreseeable does mean either or both sufficient temporal proximity, which can be a matter of years, or predictable trajectory toward death. So you know what is going to come. So that would be on the day of diagnosis with ALS, a lethal neurodegenerative condition, for example. You won't meet the other criteria on the day of diagnosis, but you do meet natural death as reasonably foreseeable. We also understand that it means when a patient has expressed a clear intent to refuse potentially life-sustaining treatment. So for instance, a BiPAP machine, which keeps the person breathing at night, breathing well at night and prevents pneumonia, for instance. Those two I would say are clear in terms of the meaning of natural death has become reasonably foreseeable. What's not yet clear is whether a clear intent to voluntarily stop eating and drinking actually means you have met the conditions of natural death reasonably foreseeable. That we'll have to wait and see as that gets discussed further in the practicing community. So it's just really important for everybody to know that natural death has become reasonably foreseeable means today what it meant 6 months ago, which is not a prognosis of 12 months. It is sufficient temporal proximity and or a predictable trajectory toward death. So those are the changes, but for more and continually updated information on MAID law in Canada, I would invite you to go to eol.law.dal.ca, where we post as much useful information as we can.